Hello, everyone, and happy Monday. My name is Cece Schnapp, and I am chair of the Bench and Bar Committee for the Bankruptcy Court for the Northern District of Georgia, and I am pleased to welcome you to our webinar today. This is the 10th installment of our Lunch and Learn program presented by the Bench and Bar Committee. So I will go through a quick housekeeping note or two and then pass it on to our panelists who I know you are all here to see today. So the materials for this presentation and a recording of the presentation will both be available online after the session. They will be on the court's website, and I will also share a link to that. It is ganb.uscourts.gov/bench and bar committee. And I will note that the materials for all of our past programs are also available on this website. So please feel free to review and to share with your colleagues. Now, I would ask that any questions you have, please put them in the Q&A box as we go along. We will monitor and address accordingly. I will note that our panelists have a tremendous program prepared for you today and will likely anticipate those questions. But should any remain at the end of our session and we have time, we will open it up for questions then. So without further ado, I would like to introduce our esteemed panelists. I'm going to keep my introductory remarks very brief, but know that each of them are incredibly accomplished and very impressive, and I'm delighted to have each of them here today. So to begin, we have Marty Ochs. He joined the United States trustee in Atlanta as a trial attorney 15 years ago. Prior to that, Marty was in private practice in New York for 20 years, where he was a Chapter 7 and 11 trustee and handled cases for debtors, creditors, and committees. We have Leon Jones, co-founder of the law firm Jones & Walden. Since graduating from law school, Leon has concentrated his practice in the areas of bankruptcy, debtor, creditor, and commercial litigation, and has an emphasis on representing individual and small business debtors in Chapter 11. He also serves as a Sub 5 and Chapter 11 trustee. Leslie Pineyro is a partner at Jones & Walden, and she joined the firm in 2008. She represents clients in a variety of legal matters in state and federal courts and business transactions. David Whitridge is our creditor representative here today, and he has his firm Whitridge Law, LLC. He has been representing secured creditors for the last 20 years, particularly in bankruptcy and real estate matters. So please join me in welcoming our panelists, and thank you very much for attending.
Okay. Marty, are you there?
Yeah, I'm here. Leon, I thought you had the first slide.
Okay, good enough. I'll take it away. So, the first issue that the topic here is, Chapter 11, and, getting started in Chapter 11. And so in order to do that, the first question is, are you stepping into the right chapter? Do you want to file, if you're representing a debtor, and obviously the attorney for the debtor is the one that is choosing the chapter, are you filing or recommending that your client file a Chapter 7, a Chapter 11, Chapter 12, or a Chapter 13? 7s, 12s, 13s are outside the scope of this presentation. This is really just about getting started in Chapter 11. And so what we are going to focus on today is, choosing a chapter, which chapter you step into, and then assuming that is a Chapter 11, then what are the initial phases of the case, getting the petition filed, the IDI, and the 341 meeting. So it's really primarily focused today on administrative matters, which will be the second part of the session. And then the first part of the session will be just really looking at the different opportunities, the different choices that have to be made with respect to actually choosing the type of Chapter 11 that it needs to be filed. So Marty, if we can go to the next screen, please. So there are really three different types of Chapter 11 now. We're not going to spend a lot of time here today talking about the history of the enactment of the SBRA, the Small Business Reorganization Act of 2019. We're just going to focus on, a practitioner level. What do we have right now? So taking it from the top, the first type of case is a subchapter 5, and that is eligible to certain debtors who qualify. We'll talk about what those qualifications are in just a minute. The second type of case is for a small business case for a debtor with debts less than $3,024,725 currently. Obviously, that's not a static number, and you'll need to check your Lexis or Westlaw for those, updates, which occur every approximately 3 years. So the third type of case is traditional Chapter 11 for a debtor who does not qualify for subchapter 5, who does not default to a small business debtor, or for even a subchapter 5 debtor for whatever reason that might have qualified that did not elect subchapter 5. So let's go to the next slide. So again, as I mentioned, as we're all aware, the SBRA was enacted in August of 2019, became effective in the beginning of 2020, and there have been since a number of modifications to it already under the CARES Act and subsequent legislation. But backing up to the SBRA, it did create a new definition of small business debtor. Small business debtor had been in the code at least since BAP CPA, but 10151D was modified, and importantly, it takes away the committee in these small cases unless the court orders otherwise, and the SBRA did create subchapter 5. So if we can go to the next slide, please, Marty. So what is the debtor that qualifies for these different types, these 3 different types of Chapter 11. A business debtor with debts up to $7.5 million that elects subchapter 5 is in a subchapter 5 case. A business debtor with debts up to $3,024,725 that does not elect subchapter 5 is in a small business case. And as I mentioned, a business debtor with debts over $3,024,725 that does not elect subchapter 5 is in a traditional Chapter 11 case. And if I haven't confused you, I confused myself at some point when I was getting ready for this. So I will try to share I did not, this chart, I don't know if you can see it, but I have prepared a flow chart. And if anyone wants it, they can email me and I will send it to them. It is not part of the materials because it was recently created. And also it has not been vetted by the proper authorities, which are namely Leslie and one other person who will go unnamed. But this flow chart will help you go through the different debt amounts and kind of track, where your debtor might end up. So the other things to keep in mind, and if, which with respect to how the debtor flows and what the opportunities are for choosing, the proper form of Chapter 11, it will depend on whether or not your debtor is a business debtor. And I say that in the vernacular. The intricacies of that are obviously more complicated than whether or not they're a business debtor. But for purposes of subchapter 5, the debtor must be engaged in commercial or business activities. At least 50% of the debt must arise from business activities. So you have to have 50% or more business debt. And you cannot be engaged, you cannot be a SARE, single asset real estate debtor. There are obviously a few other technicalities. You cannot be an affiliate or of a public company or a public company, et cetera, which we typically don't see around here in the Northern District of Georgia that much, except for, I guess, Judge Stigler did have one published decision on this exact point early on, I guess, the Serendipity case. So
if I can chime in,
sure.
I would just say for folks that are meeting with clients and trying to figure out if you fit into these buckets, it does go along with figuring out, would they be better off in a 13 or a sub 5? And that sometimes is going to hinge on how much is their mortgage, if you're talking about an individual, versus how much is their business debt, may make that decision for you, if they in fact qualify for both a chapter 13 and a sub 5 chapter 11.
So the point being, Leslie, there is you would have a situation where you might not qualify for a 13, but would fit better into a sub 5, correct?
You could have it both ways. It may be that you could actually fit into a 13, but may prefer to be in a sub chapter 5 for various reasons, such as if you are an entrepreneur, it is hard to be in a chapter 13 for 5 years, whereas in a sub 5, you confirm the plan and you can close the bankruptcy and just continue to operate pursuant to the plan, so that if you need to enter into leases or do things of that nature, you have the freedom to do it. However, one issue you need to look at to make sure this individual qualifies for a sub 5 is that they have 50% of their debt is business debt. And sometimes you will find out that their mortgage causes you a problem, that it trumps the business debt.
Yeah, the Northern District of Georgia, particularly the Atlanta metro area, together with places like Los Angeles, you have some high income people possibly, but they also have a big mortgage because of the real estate cost. So a lot of times the mortgage will kick people out of the business debtor qualification because that mortgage is more than 50% of their total debt. In which case you have to look at chapter 13 or traditional 11. What is, as again, the debtor, not just with respect to the debt ratio, business debt versus debt which is not business debt, and that is a catch, as Leslie just and Marty just talked about. That's sometimes a showstopper on your sub 5 election. The other one, which can be a sticky wicket or a disqualifying event, is whether or not the debtor is engaged in commercial or business activities on the petition date. And the way I like to think about it is the second question on the screen, and that is active operation of a business required? And that's sort of a trick question on purpose, because the answer to that is no. The debtor does not have to be operating a business. That is a test, for example, in a chapter 12, where you have to be involved in farming operations, but subchapter 5 does not require business operations. So you don't technically have to be a business operator. You have to be engaged in a commercial or business activity. There are a number of different published decisions on that, going all different ways. If that's a close call for your debtor, you're going to need to delve into that and look at the case law a little closer.
Go ahead.
Okay. Just a couple of cases on just hitting the high points really on what is business debt. It's there is a test or two that have been developed by the courts. I would say a common sense approach is going to answer the question in most instances, but just for today's presentation, we picked a couple of cases. The N. Ray Sullivan case out of Colorado from would have been a year, but now going on 2 years ago. Basically, the obligations under divorce decree were held not to be arising out of a commercial or business activity, even though the obligation in the divorce decree related to the business debt, the business asset of the couple. And N. Ray Blue out of North Carolina, again from 2021. Here, the debtor had a residence, former residence being rented out. And so the repairs costs with respect to the rental home were considered business debt. So those are just, two examples to kind of think about and put this into perspective. I guess we can go to the next slide. Again, we've talked about that 10151D, the definition of a small business debtor was tweaked by SBRA, and the debt limit there, that number, obviously you can tell is not a static number. It is one of the numbers that is periodically adjusted but it's $3,024,725. The debt limit does not apply to it's non-contingent and liquidated debts, which must fit into that $3 million bucket. It also excludes the debts to affiliates. As we've already talked about, 50% of the debt must arise from commercial activity, and the debtor cannot be a single asset real estate debtor. It must be engaged in business activity. And then that 10151C is where a small business case is the case of a small business debtor that does not elect. So that's where you follow the flow chart to see where you land.
I would just add that if you guys are looking for the definition of single asset real estate debtor, it's right there next to small business. You can read it all at the same time. It's at 10151B. And if you are representing a single asset real estate debtor, write your deadlines down, because while it is a general chapter 11, it's got some additional rules baked into it that you need to know.
Which is a great place to point out that just becoming familiar with the code before you file the case is a really good idea. And, so take the time to review the definitions and, become familiar with them so you don't get trapped in missing a deadline and, hurt your case. That can be a real problem. I dealt with that in a case last week, and, the debtors council had some fair amount of egg on her face. And so it's best to become familiar with that. So let's talk about some of the highlights of a subchapter 5. In a subchapter 5, a trustee is appointed in every case and has the duty to facilitate confirmation of a consensual plan. Unlike a regular chapter 11, there are no U.S. trustee fees, and so that is an enticement to many debtors not wanting to pay the quarterly fees that are due to the United States trustee. And so there are no quarterly fees or U.S. trustee fees in the subchapter 5 cases. Only the debtor and no other party may file a plan, but the debtor must do so within 90 days. And so that's an important deadline to keep in mind. So if you're going to file a subchapter 5, make sure you calendar that date right at the beginning so you don't miss it and you don't run into potential problems. In a subchapter 5 plan, the plan may modify residential mortgages if new value was not primarily to acquire it and loan proceeds were used for the small business. And that's defined under 1190 sub 3. There are also changes in the confirmation rule. So the absolute priority rule is no longer exists in a sub 5, and there is no longer need for there to be one impaired accepting class. So these differences are important to keep in mind when choosing to file a subchapter 5.
So, again, to kind of to follow up on what Marty is saying, recapping on subchapter 5 versus standard chapter 11, you have no creditor committee and no quarterly fees. You have no requirement for cram down that you have an impaired accepting class, no absolute priority rule, and the plan can modify a residential mortgage. All of these, the first two are obviously just fundamentally provide the debtor a little bit more leverage. The second one in particular, the loosened or relaxed confirmation requirements, provide the debtor a little bit more leverage in negotiations on confirming a plan. And the modification of a residential mortgage goes back to the comments that both Leslie and Marty had about whether or not you are recommending a chapter 13 to your client or a subchapter 5, assuming the debtor qualifies for both. Obviously, it'd have to be an individual to be looking at a 13 with a residential mortgage. But, the typical example of that we've been giving and, seeing some of, although not as much as I would have thought by now, would be like your SBA second, where the debtor gets a small business loan and is required to pledge their house. And obviously that lien was given with respect to business debt. And so you could try to strip down or that mortgage to the value in a sub 5. Importantly, I guess it's the 5th bullet point on this slide is the modification of the plan. If you're in a 13, to go back to that, you can have a situation where a plan modification is required by the parties, by the non-debtor parties, based on based on either reduced or more likely increased income during the course of the 5-year or 3-year plan, as it were. Finally, the last bullet point here is the projected disposable income. In a subchapter 5, if you can obtain confirmation of that plan under 1191A such that it is a consensual plan, and by that, all the impaired classes have voted in favor of the plan. So if you can accomplish that, if the debtor can accomplish that, then there actually is technically no projected disposable income requirement that the code would, that the code or the court would impose. And also another potential debtor advantage in a sub 5 over what most likely these type debtors in a 13 would be in a 5-year plan. So you have some ability to try to affect a 3-year plan providing for payment of all of the debtor's disposable income during a 3-year period of time under subchapter 5.
So would you think, Leon, that's an advantage in a sub 5 over a 13, for instance? Do you think that would gain?
Yeah, I mean, potentially. I mean, there's no real guidance under the SDRA as to what tests the court should use in order to determine whether or not the debtor should be required to propose a 3-year plan versus a 5-year plan. I'm not really aware off the top of my head of even any case law that goes down that avenue. So I think that's an area that's open for some litigation or development of the case law. But in the context of this conversation, a creditor or trustee could argue that by analogy, and I don't think it would necessarily carry the day, but analogy that, hey, if this were a 13, the debtor would be required to pay for 5 years.
I haven't seen any litigation over that yet myself. Yeah. I was wondering whether you had, as a sub 5 trustee.
I've looked at that issue, and there's almost no case law on that, and there's no guidance in terms of 3 to 5 years. Now, if you're a secured creditor, that may not be that big of a deal because typically you're treated in a particular class and it is what it is. But if you're an unsecured creditor, that can make a huge difference. If it's operating and making significant income, the difference between 3 and 5 years can be enormous. So, but I don't even think there's any case law on how they determine whether 3 to 5 years is appropriate. So that I think from a creditor standpoint is very important if you're secured or unsecured, but obviously it's very important to the debtors, attorneys to know if you're going to have an aggressive creditor and what they're going to be looking at in terms of that issue.
So that's something to keep an eye out for.
Yeah, and I would say this, Marty, I mean, there's usually something else that's driving the debtor that requires them to propose. There often is something else that might require the debtor to propose a 5-year plan. It could be the liquidation test. The debtor needs that amount of time in order to fund the required payments in order to retain any non-exempt assets. It could be a priority tax issue, which is going to drive payments over 5 years. Although you could pay the taxes in a sooner period of time than that. Sometimes you have some large tax obligations which are going to require a 5-year payment plan just for them alone. And so prior to my recollection is that prior to there being the projected disposable income test in these cases, you would have really relied on the good faith test, which is still a requirement under 1129A anyway. So I think if you're in David's shoes and you've got an unsecured creditor and you just don't think the debtor is paying enough, you've got 2 potential arguments. One is, okay, it should be a 5-year plan, and then you try to create some case law on that, but I would argue that you would be looking at some of the good faith, factors, almost like the kitchens test in the 13 or something like that, to argue that it should be a 5-year payment.
And I'll say from debtors counsel standpoint, typically if you have 3 years, you probably have a reason, like maybe you're selling an asset and generating money on top of the 3 years, or if the creditors have an issue with it, they're likely to reach out to the sub 5 trustee, who's likely to reach out to you. And then the sub 5 trustees put on their sort of mediator hat, and they help everyone find a middle ground. At least here in the Northern District, that's how it's been.
One factor for I guess debtors to consider is, and this seemed to be a pretty good argument, is if your principal is older and he's looking at retiring soon, I think that's a pretty good argument to say, hey, it should be 3 years as opposed to 5. If he's at that point where, hey, retirement's coming up, I think that's a pretty good argument for a debtor to make. But if the person's maybe middle-aged and they're going to be working for a long time, the business is going to go on, maybe the 5 years is more appropriate. So
one of the things to keep in mind, is comparing a sub 5 to a regular small business chapter 11 is that the same reporting requirements apply, and debtors have an obligation to file their monthly operating reports. So you have to keep in touch with your client, make sure that is happening, and make sure you're following the operating reports. If you don't, you may find yourselves facing a motion to convert or dismiss, which is obviously never pleasant. And so just make sure that you're working with your debtors to keep filing the operating reports and all the other reporting requirements that are basically the same as in a regular chapter 11.
Marty, I think we can maybe pass over this slide and the next one. I think we've talked about chapter 13 a good bit and how it relates, and let's move on to the actually getting the petition filed.
So oftentimes when we meet with chapter 11 debtors, sometimes we're meeting with them right when some emergency is coming their way. Maybe they've been involved in litigation and the litigation has reached a boiling point. They've run out of money to defend the litigation and they've got a hearing coming up. There's a foreclosure for whatever reasons. Just like all debtors, chapter 11 debtors usually come to you with a fire that you're trying to put out. So most often we are filing what's called a skeletal petition. That being said, a skeletal petition is pretty skeletal. It just lists all the creditors so that they all get notice. It lists the 20 largest unsecured creditors. And it has just the basic information like the tax ID or the social security number. However, in that first meeting, we do everything we can to try to find out at least the beginning of the information for everything that's on that statement of financial affairs. And it may not be in a format yet to where we can file it because we need to dot I's and cross T's, but you really don't want to find out that you've got a surprise on the statement of financial affairs with a chapter 11 debtor. But that being said, you can file a skeletal petition, which we often do. I would say 90+% of our cases are started with a skeletal petition with the full schedules filing within 2 weeks is when they're due. The 20 largest unsecured creditors, and that's because they're in a traditional chapter 11, that's really who they're going to look at to solicit for the creditor committee. It's still required in a sub 5. The mailing matrix, so everyone gets notice of the case, and the filing fee, which I don't know off the top of my head. I bet Leon knows what the filing fee is off the top of his head.
I think $17.39.
Yeah, it's a significant number. It's much higher than the other chapters. If it is a corporate debtor, you need a corporate resolution. If it's a LLC, those are the members. If it's an Inc., you got to look at the bylaws. You got to look at the operating agreement. If it's not single member or single shareholder, you may need more than one person to approve this bankruptcy. And you need to look at the bylaws and you need to look at the operating agreement and see, can that be done with a phone call? Can they have a meeting over the phone? Most of the time they can. You need to make sure that meeting takes place and that you get a written resolution, shareholder consent, whatever it is you need, and you file that on the docket so that everyone can see it. You don't want to find out you didn't have authority to file the bankruptcy and it's too late at that point.
And Leslie, let me just make a plug here for a second. Although it's not a requirement for the filing, it's going to become a requirement once the case progresses. is to make sure that your client has appropriate insurance, because without appropriate insurance, the case is not going to last in Chapter 11. So in my opinion, even though there's usually a frenzy at the beginning of a case, getting ready to file, that's more Leslie and Leon's problem, because they're the ones meeting with the debtors who have a fire to deal with. But it's a good idea to make sure that your clients are aware that there are insurance requirements that they will have to meet. And even though the lot's going on, make sure that that's called to their attention.
And I will tell y'all, that's one of the first things the U.S. trustee wants to see is the insurance above and beyond all, which makes sense. I mean, you've got an automatic stay in place. You better have insurance there.
Exactly. So, then, there are, once the case is filed, the United States trustee will send an inquiry to the debtor's counsel asking for certain data, which will include the insurance that I'm pointing out, will include questions about the bank accounts and debtor in possession accounts. So make sure that you're working with your clients, that they're gathering up this data. There's, it's never too soon to gather all the data, because we from the United States Trustee's Office will be looking at that right away. And then also, if it is filed as a sub 5 case, we're going to have questions that we're going to need to have immediate answers to, so that we can best select a sub 5 trustee and make sure that whoever is appointed as sub 5 trustee is best prepared to handle the case. So these are the sorts of things that you want to be conferring with your client, before the clock strikes 12 and it's too late to get all those answers. So make sure that's all done timely and at the beginning of the case. The next thing is to keep in mind that small business debtors must comply with Section 1116. They have to provide the most recent financial statements, and federal tax returns must be submitted to the United States trustee. So, these are things that should be gathered up right at the outset of, getting ready to file the case. These things cannot be overlooked and should not be overlooked. Train yourself to ask your clients about these things in advance. Also, let your clients know that they are required to file operating reports. Debtors stumble by not filing operating reports. And, and it's a shame, really, if a debtor has a viable Chapter 11 or a subchapter 5 case and they're not filing their operating reports because they just didn't know. Let's work together to make sure that that's not happening, that they're getting their data together for the filing of the operating reports, and they're actually filing the operating reports.
And I'll say from the debtors counsel, and likely David would say from the creditors counsel, I don't want to find out what's going on with the operations 3 months back. Like I want to see the operating report, so I know what's happening with the debtor and I can start talking to them about formulating a plan. So the operating reports actually help debtors counsel and debtors financial folks figure out what they need to be doing as well. Because a lot of these people have just been in putting out fire mode and they haven't really been thinking about forecasting, and the operating reports frankly help them do that.
It's a tool to force them to focus, I think. It makes them take a better look at it. It shouldn't just be the United States trustee that's looking at the operating reports. The debtor and its management needs to be looking as well. So thanks for that, Leslie. Let's talk a little bit about the initial debtor interview and the Section 341 meeting of creditors. The initial debtor interview, also known as the IDI in shorthand, is conducted by the United States trustee's case auditor. That's an accounting type of individual from my office, the United States trustee, and they will ask the debtor about various things: bank accounts, insurance, financial information for the debtor. Make sure that your debtor is prepared for the initial debtor interview. It is not an under oath proceeding, but they need to be telling the truth. Ultimately, when the 341 is conducted, which will be done by a trial attorney such as myself or one of my colleagues, they're going to be asked to tell whether the information they gave at the IDI was truthful and accurate. So, it's a basic tenet in bankruptcy that debtors are telling the truth, and they need to tell the truth at every step of the way. So make sure they're telling the truth at the IDI, and then make sure that they're prepared to tell the truth at the 341 meeting. At the 341 meeting, we, the United States trustee, will be asking the debtor questions about the background of the case. How did the debtor end up there? What is the debtor's formation? what kind of corporation is it? Has the debtor been filing tax returns? Who are the debtor's obligations to? And how does the debtor plan to emerge from bankruptcy? These are all things that are, when I was doing debtor work 100 years ago, I always made sure that I did basically a mini 341 meeting with my client in advance of the 341 meeting so that they were prepared and understood what they would be asked about. The initial debtor interview will be conducted very early on in the case. And really, my office does, I think, a very good job of getting requests out for the IDI information at the very outset of the case. So be prepared for that. This shouldn't come as a surprise. There really is no reason why the information for the IDI shouldn't be in hand and given to the United States trustee in a timely fashion before the initial debtor interview. Now, as far as who attends the initial debtor interview, obviously it's, you as debtor's counsel and a principal of the debtor as well. In a sub 5, the sub 5 trustee will be there as well, and the sub 5 trustee can ask some questions as well. The IDI is not a substitute for the 341 meeting, but it's very good preparation for what will occur at the 341 meeting. So it's a good idea to make sure that your client is versed in what's going on. The United States trustee is getting at the IDI is getting a very early impression of what the debtor is about and how the debtor is going to get out of bankruptcy. The goal is not to linger in bankruptcy, but to get out. And we want to make sure that debtors are prepared and that they know what they need to do to be able to emerge from bankruptcy. At the IDI, the United States trustees we talked about earlier will want to see insurance and that there is proper insurance in place. So if there's a building, that the building is insured, it's got fire insurance and the necessary things. We don't want to see a risk where a bankruptcy case is filed with no insurance and then there's a storm or a fire, God forbid that happens, but there needs to be proper insurance on those assets. And so we're going to be checking on that. The United States trustee will also be asking about the condition of the collateral, the things that the debtor owns, and are they in good condition? Are there environmental concerns, things of that nature? And then also at the 341 meeting, the debtor should be prepared to talk about whether there's cash collateral issues and whether the debtor is taking the steps necessary to get bankruptcy court approval to use cash collateral. Think of the assets that the debtor has pledged or has granted a lien against. The debtor needs to be able to talk to those issues at the 341 meeting. And quite frankly, if there are cash collateral issues, the debtor and the debtor's counsels need to be dealing with that in advance of the 341 meeting. And that's where we lead to what we refer to traditionally as first day orders. And that's one of the most common first day orders is the cash collateral motion. The debtor,
and that's something we, of course, talk to debtors about at that very first meeting we have with them, because these are things that you have to explain to debtors that they're not going to understand. If you're operating a business, they need to understand, hey, you're not going to, if you have cash collateral, which means you've pledged your receivables, you've pledged your cash assets, you pledged your inventory, which you then turn into cash. And you can check the UCC filings and you can see if these clients or potential clients have these. Most businesses do. They need to understand that when you file that case, they can't write a check. They can't spend a penny until the court allows them to do it. So before you file that case, you need to have a budget from your debtor client. Otherwise, you're going to be sitting in bankruptcy, unable to get approval to pay stuff, and they can't operate their business. So that's just pointing out one of the things you need to be doing very, very early in your planning.
And Marty, I want to interject back on the IDI. I mean, one of the real benefits of the IDI is that it's a very, very early interaction between the debtor, the representative of the debtor, and the office of the United States trustee, because the debtor may sit in the office of their lawyer and may hear a very detailed explanation from their lawyer about their responsibilities under Chapter 11, but it's a different thing altogether for them to be in communication on the line with somebody that's with the Department of Justice in the U.S. Trustee's office. So hopefully that sends them the message and they are able to receive it.
Yeah, I think that's a great point, Leon. And, just one little side note to that is that, one of the things to keep in mind is that, you know, not a whole lot of the population has been in court before. And, it's the debtor's attorney to make sure, responsibility rather, to make sure that the debtor is prepared to be in court and to be at the 340 meetings, and that they understand what they're going to be asked, so that they don't fumfer and stammer and not be able to answer the questions that are being asked. At the very beginning of the case, the debtor should close its pre-petition bank accounts and open up DIP accounts. And so the debtor's counsel needs to be making sure that they're explaining to them what the obligations are. This is not always an easy process, but it is a necessary process. And I understand, having done this from both sides of the equation, it's hard, and it's gotten harder to open up the DIP accounts. We respect that, but the DIP accounts are necessary. It's our best way to measure what is happening in the bankruptcy case and what has happened since the filing of the bankruptcy case. So make sure that you're working with your clients to open up bank accounts, what we refer to as the DIP accounts, at what we refer to as authorized depositories. The authorized depository list is on the United States Trustee's website and can readily be gotten from anybody within the United States Trustee's office. And we're happy to share that should you not understand what an approved depository is or who the authorized depositories are.
And Marty, all the document or the requests for documents that you guys request for the IDI are also live on your website and are very easy to find and access. So even though the Office of the U.S. Trustee gets that request out very quickly, you don't have to wait. It's the same list every time, and it lives on their website.
Yeah, that's a really great point, Leslie. Don't wait for the bankruptcy case to happen to you and your client. Get ahead of it and look at the document requests that are going to be coming your way. It's not a secret. And, the United States Trustee certainly doesn't intend to keep it as a secret. We want the debtors to be prepared. So make sure you do what's necessary to get your debtors prepared. So as luck would have it, we're talking about approved depositories, authorized depositories. Here is a list of what the authorized depositories are that is maintained by the United States Trustee. There's a link on this slide that shows where you can get the authorized depository list. It's a little hard to read on this slide, but the materials are going to be posted after today's presentation. So if you ever need a hand getting that list, you can either contact the U.S. Trustee's office or you'll be able to click that link. So the United States Trustee, strongly discourages, motions to maintain pre-petition bank accounts. So your clients need to be prepared to close their pre-petition bank accounts and open up the DIP accounts. So a good bit of preparation should go into doing this. If you know you're going to be filing a Chapter 11 for a client, make sure that you've helped work with your client to get their pre-petition accounts closed and account opened at an authorized depository. Motions to, this is always a battle between debtors counsel and the United States Trustee, whether a motion should be made to approve the continued use of a pre-petition bank account. If you're going to do that, make sure that you've articulated a reason for it and that it's for a very limited period of time. The preference of the United States Trustee is that these motions not be made and that these accounts not be continued to be used. But if you're going to need to do that, make sure you have the basis for continuing to use those accounts.
And this might be the first fight you have with your debtor client, whether they really have to close their bank accounts or not. And, there are situations where it really is just something that would be very problematic for the debtor. And I won't go through a list of examples, but they will come your way. I would say communicate with the U.S. Trustee's office before you file the motion and see if you all can't walk through it, talk about it, and figure out where you can find common ground. If you can't, there's always motions and you can ask the court, but you might be surprised how far you can get with the U.S. Trustee with talking to them about it ahead of time.
So, now we'd like to talk a little bit about the employment of professionals. We're going to spend a few minutes talking about that. One of the things to keep in mind with respect to the subchapter 5 trustees, unlike other trustees, subchapter 5 trustees are compensated on an hourly basis and not on a commission basis. And so you can ask, what the sub 5 trustee is going to be charging, and you need to factor that into your budget and operating in the subchapter 5. So Leslie, did you want to take, I'm sorry, I'll take this. So, again, as I talked about, the subchapter 5 trustee compensation is on an hourly basis. You need to make sure that if you're going to retain an attorney in your chapter 11 case, whether it's a sub 5 or not, make sure that you verify the disinterestedness and do a pre-petition conflict check for your professionals. The United States trustee is going to be asking for that. It's a necessary part of the process, and you need to make sure that you've vetted your professionals for your clients in advance of the retention applications. You need to also look at whether pre-petition payments have been received or made to the counsel and professionals, and why those payments were made, whether those payments qualify as a preference or otherwise, and whether the professional is holding a retainer for post-petition services. And if so, that needs to be disclosed in the application to retain the professionals and the attorneys. Professionals can be disqualified based upon the existence of these pre-petition claims that I'm talking about. So you'll want to make sure that if you've got a professional that you're going to be working with on behalf of the debtor, that in fact these disclosures are made, and they're made in a timely basis. You don't want it to be discovered later on down the road after the professional has started to do work. That's not good for the process, and it's definitely not good for the debtors.
So if your client and your business client is likely going to need an accountant, they have to go through the same process as an attorney goes through. They have to list any conflicts, any prior representation, any work they've done for the debtor, or maybe the debtor's sole shareholder, or any affiliates of the debtor. Disclose the same way you do for attorneys. With accountants, it's going to take you explaining this process to them, because accountants are certainly not used to their fees being reviewed by a court before they can be paid. They will expect to send an invoice and get a payment. And no matter how many times you tell a debtor, don't pay that invoice when you get it, there's a chance that the person in the payables in the office gets it and they pay it. So you need to also make sure the accountant knows that you have to not only be employed, you also have to do a separate application to actually pay them after the work is done. And accountants don't really like the whole work now, get paid later, at the mercy of the court, because they haven't been through it. They don't realize that it's a very reasonable and routine process in these bankruptcies. So just explain it to them in advance, and then you'll get more cooperation out of your professionals.
And
sorry, go ahead.
Marty, if I could just interject a couple of points that kind of pertain to subchapter 5, and just a quick pointer that you mentioned about retaining a professional. In subchapter 5, there is the $10,000 carve out. In essence, I think it's under 1195, so that if a professional is owed up to $10,000, they're not disqualified from representing the debtor. And Marty mentioned, the fact that in a sub 5, you don't have to pay U.S. trustee fees, but you do have a subchapter 5 trustee that will need to be paid. And the focus of this presentation today is on getting the case started and intake and the initial administration of the case. And so, I mean, I think the important thing for the debtors council to remember, is that when you check the box that you elect subchapter 5, you're ordering up a trustee, just like you're ordering up a meal at a restaurant. And so, there needs to be a discussion with the client about what that means. Marty mentioned the hourly rate. That's disclosed in the subchapter 5 trustees verification that's filed by the U.S. trustee in conjunction with the appointment. So you know what the hourly rate is. The trustee should fulfill whatever role is needed in the case. There has been a learning curve for everybody. I think the trustees, the debtors attorneys, and how these cases are run in subchapter. So, you know, just keep that in mind at the outtake is trying to plan how that's going to occur as far as how and when the sub-5 trustee will be. Thank you.
Thanks, Leon. You know, the next thing is that oftentimes we see applications that are made to retain debtors in what we refer to as the ordinary course of professionals. The United States trustee looks at these ordinary course professional retention applications carefully, and we want to make sure that the debtors and their professionals aren't simply trying to skirt fee applications down the road. You know, one of the advantages to a debtor of seeking ordinary course retention is that the debtors can then just pay the professionals some agreed upon sum on a monthly basis. What we want to make sure of is that this is not just a substitute or an attempt to sidestep the fee application process. So look carefully at those applications before you make them and make sure that there's a proper justification for them. It's really a good idea if you're going to make an application like that to be conferring with the United States trustee to make sure that you're not just being viewed as sidestepping what is otherwise an obligation to undergo the disclosures, the fee application process, and the other things that are typically associated with professionals that are retained in a Chapter 11 case. With respect to disinterestedness, make sure it's not the job of the United States trustee to prowl around and find out. There's an obligation to be forthcoming here about whether the debtor professionals have represented anybody, whether they've represented insiders or affiliates. You know, this is an obligation, and this is something that we're looking at very closely and we'll continue to look at very closely. So make sure that all of this has been disclosed. Nobody wants to find out that a secret has been kept, whether intentionally or unintentionally. Make sure that you disclose whether there's a relationship with the United States trustee or another creditor or a creditor of the case, not just the debtor and its affiliates. Representation of the debtor and not the principal of the debtor is a very important point. I'm working on a case now where the principal of the debtor frankly took money out of the estate, which he definitely should not have done, and that's a problem, a very real problem, and you know, borders on criminal, if not actual criminal conduct. But the principal of the debtor is not represented by the professionals representing the debtor, and you need to make sure that your principals are aware that you're not rendering legal advice to them, but rather rendering legal advice to the debtor, which is a separate entity. So there may be instances where you need to advise the principals of the debtor that they need to get their own counsel and that they would be best suited getting their own independent counsel. And make sure that this is, you know, fully disclosed in your retention applications. Make sure that it's disclosed in the engagement letters between the debtor and the debtor's counsel. These are important points to not lose sight of.
All right. As usual, the creditors got to go last. But I'll be quick and I'll just mention a few things. As Leslie said, that, you know, the debtors are usually putting out fires. So I think one thing that's pretty important for the creditors to do at the beginning of a case is get your claims filed. A lot of times the debtors may not know exactly what their balances are, what's owed, or if they've got, you know, maybe there's multiple loans with the same lender. Get your claims filed, because then that gives the debtors an opportunity to see what's out there and what they may have to formulate their plan. That's kind of the first thing. Is just get your claims filed so the other side can see what's out there. The other thing in terms of timing is these cases that I've been involved with, they move very fast. And if you're going to need to get experts, I think one of the things is you want to consider that sort of right at the beginning and get those lined up if you need to on, you know, value on real estate or anything where you're going to need an expert, that you want to consider that right at the get-go. As Leslie also said, that you're putting out fires. Typically, debtors' attorneys don't propose adequate protection payments or orders to use cash collateral. Sometimes those can sit for a long time. where there is no motion to use cash collateral. So if that doesn't come out of the debtor's attorney, then you need to be prepared as a creditor's attorney to file that and kind of get that ball rolling. The other thing that's kind of important at the beginning of a case from a creditor standpoint is if you've got guarantors, that can help with a negotiated plan. If you're going to be suing the guarantors or pursuing them, there's no co-debtor stay. So that's something to consider right away. Is it worth pursuing the guarantors and, continuing to work on the Chapter 11 case, but also, will that put leverage or give you some leverage in the Chapter 11 case where you can work out a negotiated plan and get the plan confirmed, and not spend a lot of time with attorney's fees and just get your client what you need. So that's those are kind of the big things right off the bat. I know we don't have a lot of time left, but I think the other thing too, the last thing I'll say is from the creditor standpoint, is it's much better if you can get a consensual plan with debtors counsel. If you communicate with them, let them know what you have. If you've got problems with your documents and they bring it up, everything doesn't have to be World War III. I've seen, and everyone's seen cases where, a creditor will fight tooth and nail on something that's avoidable. And maybe it's because they don't want to tell their client, but that's one thing you need to be able to tell your client, hey, if your documents are messed up, they're messed up, and you're going to have to live with that in the case and do the best you can. So, consensual plans typically, especially in these fast moving cases, are much better, much more advantageous to the client to keep those on track and not let everything get totally sideways. And communication is the key. Just reach out to debtors counsel and let them know what you can work with and hopefully get a consensual plan formulated. I'll say one last thing on the elimination of the opportunity for an unsecured creditors committee. We typically don't see those a lot, but as I mentioned in the earlier, being an unsecured creditor obviously is a lot different, and with the 3 to 5 year difference in what the plan could go, that's a big issue, and I don't think it's decided. There is some case law.
Well, actually, I was going to interject, David. I didn't mean to interrupt you, but at the very end, we had some incoming information, thanks to Judge Cavender, on the 3 versus 5 year plan. There is a decision out there on this point, which is the urgent care physicians. It's a 2021 case from the Eastern District of Wisconsin at 2021 Westlaw 6090985. So thank you to Judge Cavender for submitting that to us, and I look forward to reacquainting myself with that decision and hopefully hearing about it at one of our upcoming sessions.
I'll say this about that case. It does address the issue, but what it focuses on is whether 3 to 5 years is fair and equitable. It doesn't really give a roadmap or sort of what the standards are. It really seems to focus on whether 3 or 5 is fair and equitable. So from a creditor standpoint, it's not a good decision. It certainly it does address, and it does address that issue, but it really seems to focus on what's fair and equitable as opposed to other factors. And it's a good case to look at, but it's very fact specific, and I think it's really heavily talks about fair and equitable. And I think either side can use the case, but it's not, there's some language in there that's not very helpful to creditors. It kind of says that the default is 3 years, and it's sort of up to the creditor to prove maybe 5 years is more equitable and fair to extend it. So it's a good case to start with, but as I said, it's not real friendly to creditors.
So why don't you?
CC, we're at 1 o'clock. I don't know where that puts us.
Yes, I just was gonna say that we are right at the mark. So I think that should do it for us today. And I know that there may be some other thoughts or questions. I will again say that the materials will be available on the court's website in a recording. And should you have any lingering questions, I'm sure you can contact our panelists, but I would like to say a very big thank you to all of them for taking the time to put together this program, and to our IT staff also for helping facilitate this Zoom, and for everyone for attending today. So thank you very much, and we hope that you have enjoyed our program.